Service 1828.
Do not leave. Get out of the car. Then get out. No. Then get out.
Get out of the car.
Get out of the car.
Get out of
What's up, you guys? Welcome back to Southern Draw Law. My name is James White, criminal defense attorney, former prosecutor, former police officer. Today's video comes to us from the Forbes Breaking News YouTube channel. Now, this video is a little bit different than what I normally do because the video we're actually going to show is purported to be an independent analysis by a retired sheriff named Russ Martin, who's been hired to do an investigative breakdown. Now, the incident in question was an officer-involved shooting that left a 21-year-old pregnant woman named Takaya Young dead, and the Officer Connor Grubb, charged with her murder. This occurred just on the outskirts, from what I understand, of Columbus, Ohio, in a place called Blendon Township. Now, I have made substantial edits to the video to highlight the portions relevant to our discussion, but I do encourage you to go to the Forbes Breaking News channel to view it in its entirety and give them the credit for the journalism they did to bring the story forward. Now, the reason I've chosen this video specifically is to bring attention to a couple of things that are being overlooked about the case, and also highlight the dangers of worldview bias in independent investigations, as well as to give my thoughts on the case and what I think is going to happen with it. So with that, let's watch part of the video and then we'll come back and talk about it.
I'm Russ Martin, former Delaware County Sheriff and Chief of Police for the City of Delaware. I worked in law enforcement for more than 40 years before recently retiring. I have no connection to the Blendon Township Police Department, but they asked me to provide and review some context that might be helpful to the general public about the body-worn camera video from the tragic officer-involved shooting that recently happened. I want to be clear, I won't be making any conclusions about whether what the officer did was right or wrong. That's the job of other agencies. I'll simply offer analysis similar to what any investigator might look at when reviewing body-worn camera video of a use of force incident. Let's take a look at the video.
Now, this retired law enforcement officer of 40-some years experience is claiming that he is not going to make any conclusions, but if you pay attention, he's giving you his conclusion in the way that he frames the analysis. So I'll stop the video periodically and highlight where he pivots from analysis to opinion.
Police Officer 1 was already in the front of the Kroger parking lot after a citizen called and asked for help after locking herself out of her car. This is a common call for police. We can see that he's using tools police carry in their car to try to open the locked car door. Police Officer 2, who had just finished with a nearby car accident, is on the scene and also tries to help unlock the citizen's car. As Officer number 2 is working, a Kroger employee approaches him from behind and points to a woman getting into her car. The Kroger employee tells Officer 2 that the woman getting into the black Lexus has just stolen things from the store. Police officers routinely may be focused on one task in a public setting, then, when abruptly interrupted, must then redirect focus to a more pressing matter. Officer number 2 quickly approaches the Lexus and attempts to talk to the suspect. He repeatedly tells her to stop and get out of the running car. It's well within the legal authority of police to temporarily stop and detain anyone believed to be part of a potential crime.
So here he makes the statement that it's well within the legal authority of police to temporarily stop and detain anyone believed to be part of a potential crime. Now, in my opinion, this is a dangerous statement for an expert to make because it actually draws a legal conclusion that, in my opinion, he's not qualified to make. In fact, if he were hired as an expert in this case, it would be for his law enforcement experience. It would not be for his legal analytical acumen. And he would not actually be permitted probably to make this statement to a jury because it's outside his field of expertise. He's a retired cop. He's not a lawyer. There must be an analysis about reasonable articulable suspicion of criminal activity here before we determine what was within the legal authority of the police. To just make this blanket statement that the police can, detain anyone believed to be suspected of a crime is actually not true. In fact, the entire case depends on that initial legal analysis about whether or not there was reasonable articulable suspicion. And he's not the guy that you would hire to make that determination. He's not a legal expert. He's a police officer. Now, I take issue with his statement not because I don't believe that the police actually had legal authority to detain her. I believe, based on the circumstances, they absolutely did. We pretty clearly have the baseline reasonable articulable suspicion of criminal activity here. You have a store employee reporting an act of theft that they allegedly observed, pointing to the suspect, and then you have the police on scene to do the follow-up. That's not my issue with his statement. My issue is that he started with his credentials of a 40-year law enforcement officer and retired sheriff, which would lead people to believe that he's an expert. And he is in something, but it's not legal analysis. He begins by telling people that he has no affiliation with the department, and that's designed so that you won't think that he's biased. And then he also says that he's not going to be drawing any conclusions about whether the officer was right or wrong. And then within the first 2 minutes of opening his mouth, he draws a legal conclusion about one of the most important aspects of the case. The danger of that is that this is the Forbes Breaking News YouTube channel with 3.4 million subscribers. Nearly 1 million people have seen this video, and because of his statement, many of them will have dismissed from the get-go whether the police were correct in attempting to detain Miss Young without any further analysis whatsoever. Furthermore, anyone watching this video now thinks that the police can detain anyone believed to be part of a potential crime. So it's like it's not even up for debate. There's been no offering of a definition of what it means to be believed to be suspected of a potential crime, or who gets to do the believing and who gets to do the suspecting. Well, it's absolutely up for debate. It's what the whole case hinges on, and he just offered himself as an expert to anyone watching this video on this matter, and in my opinion has tainted the court of public opinion and potentially the jury pool. Let's move on.
Officer 1 appears to notice what his colleague is doing and walks over to assist. As Officer 2 continues to loudly tell the driver to get out of the car, Officer 1 walks past him briskly and moves around to the front of the car. Police officers are generally at greater risk either directly in front of or behind a car for obvious reasons. Drivers can drive forward or backward into the officers when they're in that most vulnerable position.
Here he says police officers are generally at greater risk directly in front of or behind a car for obvious reasons. This is not analysis, it's opinion. And guess what? Everyone is at a greater risk in either of those positions, not just police officers. And again, my issue is that it removes this part of it from the debate. He's already setting the stage to frame this as a justifiable use of force because of the risk that he just associated with the officer's position. And there's been no consideration given to whether that was a reasonable position to be in, who made the decision. None of that is in his analysis that he's claiming to make. It's all his opinion.
Officers are trained that one of the most dangerous encounters they face on the job involves a driver seated in a car. It's dangerous because there are many places in a car where a weapon can be hidden and the driver's hands are often out of view. While this suspect didn't have a weapon, the officers didn't know that at the time. 19 seconds into the encounter, the suspect rolls her window down a few inches and asks why she's being stopped. Officer 2 tells her that a Kroger employee has accused her of stealing. Citizens can ask why they are being detained or ordered to comply, and, in most cases, when there's time and no urgent circumstances, the officer should provide an answer, as Officer 2 does.
Here, he does a bit of a bait and switch. He tells us that police officers are trained to consider a suspect seated in a vehicle as one of the most dangerous encounters they'll face on the job. And that's true. They are trained to believe that, and they've actually managed to train the courts to believe that too, and that's how we ended up with Pennsylvania versus Mims. But then Martin goes on to explain that the reason this is one of the most dangerous encounters is because of the inability of the officer to see the driver's hands or to know whether there's a weapon that the driver could access. Then he says that while Miss Young didn't have a weapon here, there was no way for the police officers to know that. Now, I don't disagree with that. All of that is true. It's just that there's a little bit of mixed decision-making going on here. He may not even realize how biased his analysis is, but he's offering a pretextual justification for what's getting ready to happen based on training, but he's leaving a very important part of that training out. You see, officers are in fact trained to understand that one of the most dangerous positions they can find themselves is with a person seated in a vehicle for the very reasons that Martin points out. They can't see the hands, they don't know whether or not the person has a weapon, and the very nature of the encounter is dangerous. But because of those factors, officers are also trained to stand behind the protected areas of the vehicle, like the post right behind the driver's window and the passenger's window, sort of in the vehicle's blind spot at a bladed angle, so that they can see as much as is possible to see about what the driver's doing, any furtive movements they might be making, and they will also be in a more protected position and harder for the person to find them if they're going to produce a weapon and fire a shot. What he fails to mention is that Even though police officers know that a person seated in a vehicle is one of the most dangerous parts of their job, this officer has intentionally placed himself directly in the death funnel that is the front of the car. So you guys tell me how much sense it makes to simultaneously make the argument that the officer is reasonable in establishing a heightened sense of threat here, but also that the officer standing directly in front of the car, where he could see less of Miss Young's hands and have no cover in the event of a dangerous threat, is reasonable. But again, the most dangerous part of this guy's analysis is that he dismisses this issue for debate. It's almost like we just have to accept it for what it is. This police officer standing in front of the vehicle. The vehicle has a person seated. That's one of the most dangerous things that they can encounter. But all of the nuance attached to those concepts matters, and they're not being discussed. And that's where his expertise actually is discussing this stuff, not making legal opinions. Let's continue.
Ohio law requires everyone to comply with the lawful order of a police officer. Although she's been ordered to get out of the running car many times by now, the driver starts to turn the steering wheel to the right as Officer 1 is directly in front of the car, in a clearly vulnerable position. Officer number 1 draws his firearm and again loudly orders the woman to stop the car. Police officers are trained to draw their firearms when threatened with deadly force, which can be from a gun, a knife, or a vehicle. In the next second, the driver steps on the gas and the car moves forward. When you look at side-by-side footage from both officers' body cameras, you can see that the suspect's car pushes Officer 1 backwards several feet. It's clear from the video that the car makes contact with the officer. In the next second, you can see that both of Officer 1's feet are off the ground. At this moment, Officer 1 fires a single shot through the windshield. Officer 1 is then able to slide off the hood of the moving car as it rolls towards the building. Officers run to keep up with the moving car, and from the video, it doesn't appear that the officers would have any way of knowing whether the driver is in control of the car. When the car stops, they act quickly to get the driver out of the car, which is what they are often trained to do. I was asked only to make observations of what I saw from the officer's body-worn camera video from this brief encounter. While we have the benefit of slow motion after the fact, it's important to remember that police officers have to make these difficult decisions in a split second, often in the middle of a highly stressful and very dangerous situation. With over 40 years in law enforcement, my review is based on my experience as a law enforcement veteran who has been exposed to some of the best training available and as one who managed a police department and a sheriff's office. In my career, I've noticed that many people will make judgments without all the facts. Sadly, that's the world we live in today. It's always tragic when unpredictable encounters lead to the loss of life. Frankly, with any death, there is often inconsolable grief. The events and outcomes of the decisions made on that fateful day will have a lasting impact on the family of Takaya Young, the community, and the officers involved.
All right, so to me, this is the worst part of this whole independent investigation. He mentions, for whatever reason, an area of Ohio law about there being a requirement of people in Ohio to follow lawful commands. Now, he's right about that. It's right in the statute. I mean, it's plain language. And I even agree that the orders given to Miss Young were lawful, at least at the outset, and that the detention was lawful under Terry versus Ohio, under the idea of reasonable articulable suspicion that she had committed a theft. But here's the dangerous part of his delivery of this information. He does nothing to separate the reasonableness of the use of force, the de-escalation requirement, or anything else from his original statement about following lawful commands. He never offers any consideration as to whether or not the commands were lawful or whether or not the officer violated policy at any point during this encounter. He ties the legal requirement of following a lawful order directly to the officer's vulnerable position without mentioning who put him there or why, and then ties that directly to the escalation to deadly force, and that is all packaged up in this overarching concept that people were supposed to follow police orders. By doing this, he frames all of this as being justified, where his analysis starts with lawful commands, and then he doesn't do any separate analytical work to try to figure out how we got here or why. He didn't do anything to unpack this situation. So it's presented as this package that's surrounded by a lawful order that Miss Young was supposed to follow. And again, I agree that she was given lawful commands. But what happened was this case got escalated to a deadly force situation for no reason. And by him offering himself as an expert, he makes it seem like there's a justification here, when, in my opinion, there isn't. The problem with that is that the person listening to his analysis just begins to accept that the police officer was acting both reasonably and legally prior to the shooting. He goes on to mention then that officers are trained to draw their firearms when threatened with deadly force. And then in the very next statement, he's describing what the driver is doing as the officer draws his firearm. And again, doing no separate analysis. So he's telling you that he believes the officer was justified in drawing his weapon in this particular situation without actually saying the words. His field of expertise is police culture, organizational leadership, criminal investigation, administrative policy making, not legal analysis. And he does nothing to talk about any of the policies attached to what the officer did. He didn't really talk about what he's an expert in. He used his expertise and his experience as a way to bolster his credibility to say a bunch of stuff he wouldn't get away with in court. He even mentions that officers are trained to draw their firearms when they're facing a deadly threat, but he does nothing to define a deadly threat or mention what law enforcement policy and procedure says about how to get to a legal use of deadly force. Even though as a sheriff, he was the person who was responsible for being the head of that policy-making decision, and by the way, holding people accountable in not following the policy within his own agency, which again is where his expertise is situated. So anyone who even slightly trusts the police and watched this video 11 months ago would have already come away with the opinion that the officer was justified in the shooting. And if we look at the comments section of this YouTube video, you can see that people in the public are already saying that the officer was justified. Now, it took 11 months for the Ohio Bureau of Investigation that's attached to the Attorney General's office to complete their report and for the prosecutor to bring charges against this guy. And now everybody is wondering why. Why, if what this expert says is true, would this officer even be charged? Well, it's because their expert is a hired gun, probably funded by the police union. I mean, how else would he get the job? They certainly didn't call and ask me what I thought. So here's my take. He's telling them that this is a deadly force threat, and it's actually not. And here's why. Applications of deadly force are specifically outlined in police policy and procedure manuals. Now, I have parts of the policy and procedure manual for the Blendon Township Police Department. I'll leave a link in the description, but here's what's relevant as it relates to the use of deadly force. Well, first, before we get to deadly force, as this officer should have done, we're supposed to take a step back and see whether there's something we're supposed to do along the way. So let's look at 300.2.1, the duty to intercede and report. Any officer present and observing another law enforcement officer or a member using force that is clearly beyond that which is objectively reasonable under the circumstances shall, when in a position to do so, intercede to prevent the use of unreasonable force. So let's look at 300.3.6, alternative tactics, de-escalation. When circumstances reasonably permit, officers should use nonviolent strategies and techniques to decrease the intensity of a situation, improve decision-making, improve communication, reduce the need for force, and increase voluntary compliance. This includes attempting verbal persuasion. So let's look at 300.4. An officer may use deadly force to protect him or herself or others from what he or she reasonably believes is an imminent threat of death or serious bodily injury. An officer may use deadly force to stop a fleeing subject when the officer has probable cause to believe that the individual has committed or intends to commit a felony involving the infliction or threatened infliction of serious bodily injury or death, and the officer reasonably believes that there is an imminent risk of serious bodily injury or death to any other person if the individual is not immediately apprehended. And then the policy goes on. This is his own policy at his own department, which, by the way, the expert did not mention at all. 300.4.1, moving vehicle. Shots fired at or from a moving vehicle involve additional considerations and risks and are rarely effective. When feasible, officers should take reasonable steps to move out of the path of an approaching vehicle instead of discharging their firearm at the vehicle or any of its occupants. This is in his own policy. Now I ask you, why is the expert intentionally not mentioning the things he's qualified to talk about and specifically offering opinions on the things that he's at best less qualified to talk about or at worst wholly unqualified to talk about? The answer is bias. Who do you think hired this guy? What if I told you that since the killing of Takaya Young, Blendon Township has fought tooth and nail to keep from giving the family records? They actually have an open case in the Supreme Court of Ohio on a writ of Mandamus, which they had to file just to see unredacted names of the police officers involved in this case. Why? Well, as part of their records request, they got the policy and procedure. And then when the police department sent the reports and other documents attached to this case, they redacted the names of the police officers because they used the statute referring to victims as a way to keep this information from the family. In other words, they classified the police officers as the victim in the case so that they could keep from giving the family the names of the police officers. So remember that when you hear these government actors on TV talking about how they want public records laws to encompass their discretion and their ability to withhold sensitive information about victims from public disclosure, remember that they want to be able to redact the victim's information from public records to keep from releasing information. And remember also that they want to be the arbiters of who is a victim under the law. And what they do is they just use it to keep from having to give information to people, and they use it to further their cover-up efforts. And now that we know that there's a back the blue bias in the independent investigation expert here, let's talk about what actually happened. Remember that Miss Young is being suspected of a misdemeanor theft. That will matter when we look at the legal authority that gives us the answers for justifiable use of force. Recall again that Miss Young's vehicle is not blocked in by another vehicle. There's no police car there. There's nothing in front of them. The only thing standing between her and escape is the police officer. The police officer who intentionally placed himself in front of the vehicle. Now Miss Young, in evidencing her intent to flee, turned the steering wheel of the vehicle all the way to the right, which should have told the police officer that her intent was not to drive into him, but was to drive around him to escape. Now, when she's seen turning the wheel to the right, in response, Officer Grubb draws his weapon. In this moment, Officer Grubb steps outside his use of force policy, improperly escalates the threat of force to a threat of deadly force by drawing his weapon where there was no deadly threat. Because it is not reasonable to believe that a person who's directly in front of you would turn the wheel all the way to the right if their intent was to hit you. In so doing, he became the primary aggressor in a felonious assault. The original officer fails to observe the duty to intercede policy. Grubb, ignoring the standard outlined in his moving vehicles policy, which calls for him to step outside the path of the vehicle when feasible, instead of discharging his firearm, instead does the opposite and placed himself on the hood of the vehicle. Then he fired a single round, killing Miss Young. Now that's the criminal investigation part of it. And that's how we get to a homicide. It's basically a killing in the commission of a felonious assault, which makes it felony murder. And if you look at the DOJ standard for the federal law standard, it actually tells us that it's not reasonable to shoot into a vehicle when there is any opportunity to sort of sidestep and get out of the path of that vehicle. But let's also look at the Graham factors and then look at Tennessee versus Garner. Remember that Graham says we look at three factors. They're loosely the severity of the offense. Okay, that's minor. That's a misdemeanor theft, and that favors Miss Young. There's the threat of escape. Well, obviously she's trying to escape, so there's a high threat of escape, so that's favoring the officers. And then there's the likelihood of death or serious bodily injury. Well, this depends on how you look at Connor Grubb placing himself on the vehicle. But the way I see it is because that is specifically against the department policy that governs this issue and his training, I believe this factor favors Miss Young. So under the Graham factors, 2 out of 3 suggest that this is an unreasonable application of force. Well, what about Tennessee versus Garner? Well, that's even easier. Deadly force is only authorized in the fleeing felon doctrine where there is a reasonable belief that the person will cause death or serious bodily injury to a person if they're not immediately apprehended. Well, 1, she's not a fleeing felon because she hasn't committed a felony. And 2, there's absolutely nothing here that would suggest that there's any threat of death or serious bodily injury to anybody that wasn't positioning himself to sit on the hood of her car. This was a case that, had she stopped, would have likely been resolved with a citation. And had Connor Grubb just stepped out of the way and let her go, they could have sought a warrant for her and arrested her later. In my opinion, this was completely unjustified. And that's why he's appropriately charged with homicide. In closing, I'm very concerned that this case will result in an acquittal. I believe the Ohio AG's Office of Criminal Investigations did a terrible job of getting this investigation completed. It was a very simple incident. It shouldn't have taken a year to come to a determination. Too much time has passed, and the hired guns from the union have made their rounds in the media and tainted the potential jury pool and the court of public opinion with their bogus offering of objectivity in this investigation. I think ultimately they will win a lawsuit, but I don't see them getting a conviction under the circumstances, not because he didn't unlawfully kill Miss Young, but because the people charged with bringing the case have failed miserably and have allowed the significance of the case to die in the media while simultaneously allowing the police union and the township to stonewall the family's efforts to get information. Connor Grubb is an honorably discharged Marine. Partly the problem with law enforcement is that cops are trained using a militarized approach that looks more like martial law than the customer service approach that they need to adopt when dealing with American citizens with constitutional rights. I think the jury will likely find the cop to be a more likable person than the victim here, and I'm afraid of where that will leave the case. At very best, we're probably looking at a voluntary manslaughter conviction, if anything, and I don't expect that he's going to get any prison time, and I wouldn't be surprised if he was fully acquitted. And this is all the stuff they don't want us to think about when they offer an expert to tell us what to think without actually telling us what to think. They also love to tell us to just relax and understand that, cops have to make split-second decisions, and we just don't get it. Well, the problem with that is that this cop had almost a minute to decide what to do. There were no split-second decisions here. He knew that she was going to leave, and he drew his weapon in response to that, which was an inappropriate escalation of force. He then put himself almost on the hood of the car and put his hand on the hood of the car. Where else was he going to go? And he knew what he was going to do when she pulled away. This was a calculated tactic that happened to be outside of policy and illegal. That's my opinion anyway, for what it's worth. But I encourage you all to go click on the links in the description, read the documents outlined in the use of force policy and the Writ of Mandamus lawsuit, and come to your own conclusions about what happened here. I'm at least encouraged the grand jury indicted him, but probable cause and proof beyond a reasonable doubt are two very different things, and the grand jury won't be the jury that's picked to do the trial. And so this will be a case won by whoever has the best storyteller and whoever can persuade the jury the most. Anyway, that's all for this one, guys. Thanks for sticking it out. Please remember to like and subscribe and leave a comment on the video. Check out some other videos on the channel and leave a comment on there as well. Until I see you again, take care. Always film your interactions with the police and keep your evidence to yourself.